application of conservative principles to the law. The society embraces the principle that the state exists to preserve freedoms, that the separation of governmental powers is central to the integrity of the Constitution of the United States of America, and that it is emphatically the province of and duty of the judiciary to say what the law is, not what it should be. The society seeks both to promote an awareness of these principles and to further their application throughout its activities. So today, for our celebration of Constitution Day, we have two wonderful speakers. I want to thank also the library for helping us put this event together. So I want to turn it over to anybody from the library. Do you want to say a few words? Welcome to do so now.
This is the director. I'm just happy that we're able to continue to support both the student organization and Constitution Day. I hope everybody enjoys.
Thanks, Colleen.
Thank you. Okay, so let me introduce to you today's speakers. First of all, I'm going to introduce Professor Josh Blackman. Professor Blackman is a professor of law here at South Texas who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of 3 books: Unprecedented, the Constitutional Challenge to Obamacare; Unraveled, Obamacare, Religious Liberty and Executive Power; and An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Professor Blackman was elected by Forbes magazine for the 30 under 30 in law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action, on immigration and healthcare. He is an adjunct scholar at the Cato Institute, and he is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league, and has a blog at joshblackman.com. He is the author of nearly 5 dozen law review articles, and his commentary has appeared on the New York Times, the Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. And I'm going to introduce, go ahead and introduce our second speaker, Professor Randall Kelso. Professor Kelso is the Spurgeon E. Bell Distinguished Professor of Law here at South Texas. He teaches and writes primarily in the area of constitutional law. He also teaches contracts and has taught professional responsibility and jurisprudence in the past. He earned his BA in mathematics from the University of Chicago in 1976 and his JD from the University of Wisconsin-Madison in 1979. Professor Kelso's articles have appeared in the Texas Law Review, Wisconsin Law Review, University of Pennsylvania Journal of Constitutional Law, Seton Hall Journal of Constitutional Law, Cardozo Law Review, Hastings Law Review, Pepperdine Law Review, and Quinnipiac Law Review, among others. Professor Kelso has been a visiting law professor at the University of the Pacific, Knight George School of Law, and the University of Aarhus School of Law in Aarhus, Denmark. Prior to joining faculty at South Texas in 1983, he taught legal research and writing at the University of Miami School of Law from 1979 to 1980, and at Columbia University School of Law from 1980 to 1982. So without further ado, I'm going to turn over the floor to Professor Randall Kelso.
Okay, well, thank you very much. And I appreciate you asking me to be here and arranging for this event on Constitution Day. I've got sort of 2 basic areas to talk about with regard to COVID and the Constitution, which is the topic of this presentation. The first one is that a lot of the media discussion about COVID regulations and are they violating people's constitutional rights really are just kind of, that's media fluff, as opposed to actual, real, serious constitutional law doctrine. In general, states are going to have authority under their just general police powers to make regulations to advance public health of their citizenry. And the test under the Constitution is just going to be a rational review test. As long as what the states are doing is rationally related to a legitimate government interest, it's going to be constitutional. And to show it's unconstitutional under that test, the challengers pretty much have to show the law is just arbitrary, irrational, or capricious in how it was drafted or how it operates and in practice. And that's what's very difficult to do, to say that what actually been done is just that irrational or that arbitrary. So you haven't really seen any actual real legal challenges to the various rules regarding face masks or social distancing or work-related rules and work restrictions in the workplace. There's been a lot of politics about it and a lot of people getting on pontificating about it. You're violating my constitutional rights to do this one way or the other. But that's all in the realm of politics. And that's important. The final point about that is, politics is important. Just because you don't have a legally winning case in court, it doesn't mean that what you're saying doesn't matter. And it's really on both sides. I noticed in the news today that there was a question of whether the University of Georgia was going to open up some forum for student voting on campus. And originally the University of Georgia said, well, we can't really ensure safety of voters, so we're not going to open up the basketball arena for early voting. And then there were student protests. Why can't you do it? Are there really health and safety concerns? And they could point out that in some of the primaries earlier, like in Kentucky, they had a large facility in Louisville where they did in-person voting, and there didn't seem to be any health problems, and it was manageable. And so their protest got the University of Georgia today to back down and change. And now the University of Georgia is going to open up that facility for in-person voting. So protest activity to suggest maybe your government decision should be changed can be very useful. And government, protests on the other side that this restriction on this work environment or that work environment may be broader than necessary, and maybe getting the relevant officials to be a little more accommodating. That has pushed some governors to backtrack a bit on certain policies they adopted, and that's all that's all part of the political dynamics, which is great. It just like the case in Georgia, it didn't involve a constitutional challenge. It didn't involve a case somebody suing Georgia for not opening up a facility to vote. It just involved activism and then Democratic actors responding. Okay. The one area, and this is the second part of what I'll focus on, the one area where there are real legal challenges going on now, and some have been successful, some have not, but there is a real legal issue regarding COVID restrictions in religious organizations, religious worship services, and other activities of religious organizations, because there is, under the First Amendment, the separate religion clauses that there's free exercise of religion, and even though the sort of basic health regulations are just rational review, which is just a generic health regulation, under the free exercise clause doctrine, if you're actually discriminating against religion in your COVID regulation regarding face masks or distancing seating or what percentage capacity you can have in your building, if you're discriminating against religion in those rules, that triggers strict scrutiny under the Hialeah case. And so if you can show that the government regulations are not just treating religion the same as all other secular organizations, if they're treating religion the same as all secular organizations, it's still just rational basis review, and the government's going to win. But if you can show that there's some discrimination against religion, that's going to trigger strict scrutiny, making it very difficult. The government then have to have a compelling interest and have to show they're using the least burdensome alternative to respond to that compelling interest. It's going to be hard for the government to do. So the real question is, how do we decide whether some regulation is treating religious organizations equally or is discriminating against religion? And that's an area where the Supreme Court, they've had a couple recent cases where the individual fact patterns decided was some government policy discrimination or not. But they've never laid out a very clear test for how do we, they just had a couple of cases said, we know in this case there's discrimination, or we know in this case there's not discrimination, to trigger strict scrutiny. But they haven't laid out really a clear test for how you should go about deciding whether some regulation discriminates against religion or not. And there are really three possibilities. I'll just go through them briefly here just to give you a sense of them, and then tell where I think the work likely of those three to eventually go. One way is to do it like under Equal Protection Clause doctrine. Under Equal Protection doctrine, if you bring a case, say, for race discrimination, you get to strict scrutiny if you can show either discrimination against race on the face of the government action, facial discrimination, or if you can show discriminatory intent. And discriminatory intent means you've got to show that there was an intent by the government actor to discriminate based on race, and that was a motivating factor in your decision. So it doesn't matter if the effect is to discriminate. You've got to show beyond the mere effect to discriminate. You've got to show it was a motivating factor, was an intent to discriminate against race to get the strict scrutiny under the Equal Protection Clause. Okay, well, you might apply that here in this context, under the Free Exercise Clause, and say that there's only discrimination against religion if it either on the face discriminates against religion, or you can show, based on not only the effects, but any background legislative history or other evidence of government motive, that there was, in fact, an intent to discriminate against religion. Okay, that's proved pretty hard in the equal protection area to prove racially discriminatory intent. It might be a little hard in the religion area to prove religious discriminatory intent for most government actors. And so that would be sort of the test that would be the least favorable to religious organizations, would be the Equal Protection Clause analogy. Okay, a second way of doing it is to just ask more just objectively, what is the nature, extent, and likely impact of the government regulation on a large fraction of religious organizations? So just in general, objectively, what is the impact? Chief Justice Roberts, in a recent opinion, involved sort of a stay. It was one of the full case. It was just that we're not going to stay some lower court opinion, but then he wrote a little concurring note about that. And in that one, he talked about we're focusing on comparable secular gatherings versus religious gatherings. And his argument was, look at the nature, impact, and extent. And if you're treating religious services and religious gatherings comparable to secular, then you're okay. You're not discriminating. If you're not treating them comparably, if you're treating them differently, if you're treating comparable social gatherings differently than religious organizations, then you are discriminating against religion. And so that was his way of sort of phrasing the relevant inquiry on discrimination. The third way was in then a recent Justice Kavanaugh dissent that is the most favorable to religious organizations. His view was that if you've got a policy, a generic policy, and if any secular organization gets some exception, so you treat any secular organization a little more favorably than others, then you have to also treat the religious organization more favorably. That basically you're discriminating against religion if religion isn't given the most favorable treatment you give to any other secular organization. Okay, well that's obviously very much favorable for a religious organization. They would love that to be the test, because that means that anytime anybody is impacted, and then the government says, okay, we're going to create one exception, then the religious organization will get the exception as well, or it'd be discrimination and trigger strict scrutiny. But that was just Kavanaugh on his own in a dissent. We don't know how the other justices like Thomas and Alito and Gorsuch would they rule on that. I think even if those other three, so even if you had Kavanaugh and then in full consideration of a case, Thomas and Gorsuch and Alito all agree with Kavanaugh that the test ought to be is there any possibility of religious organization being treated not as favorably as any other secular organization? Currently, I don't think you have Roberts. I think Roberts and the four liberals are likely to go with just generic, likely impact, large number of relevant cases. What's the comparable secular gathering analysis? As they did in the recent,
South Bay.
Pentecostal church case. And that was one of those cases where you were trying to decide, are we going to let churches run at 25% capacity, or could they run at 50% capacity? If you let some other businesses run at 50% capacity, then you have to let the churches run at 25%. And Roberts and the four other liberals said,
while in this case, what the California had done was not discrimination against religion, because they treated religion the same as movie theaters and other auditoriums where you've got people sitting together for a long length of time indoors. The allowing of 50% was for like malls where people are walking around and they're not quite as packed in and close together, or grocery stores where people are walking around not quite as packed in together. So Roberts and the four liberals said, well, you are treating religion similar to the movie theaters. Yes, you're not treating them similar to grocery stores and malls, shopping malls, but it was comparable enough, and so they just applied rational basis review. In that case, the four more conservative members of the court, Thomas and Alito and Kavanaugh and Gorsuch, all said, well, you're not treating religion equally because they've got people, grocery stores have people, other businesses have people, all of them have to be given 50%. You can't discriminate against religion. But that wasn't the majority. So as of right now, I think comparable likely impact is likely to be the test. Justice Roberts made it clear in that case that in general in these cases, he really wants to defer to the government actors, that the government actors are in the best position to balance the difficult health and safety concerns of people in different environments, that he wasn't looking to trigger strict scrutiny. Right now, most of those challenges by religious organizations have failed, but in a few cases they won. There was one case in upstate New York, challenging one of Governor Cuomo's regulations, where the lower court judge said, you're just not treating the religious organizations comparably to secular, because those organizations which were in the 50% versus the 25% were comparable enough, and religion was treated unfairly being in the 25%. So religious organizations have won a couple of those cases so far, but only when they could really show that the policy wasn't carefully thought through. In general, right now, at least on the Supreme Court, Roberts and the four liberals are looking more to defer to government judgments unless there is more sort of clear treating religion differently. Okay, and I'll stop there. That's sort of my 10 minutes take on it, and turn it over to Josh Blackman, and then after that we'll take questions.
Okay. Professor Kelso, thank you so much. Let me get my camera set up. Okay. It's a pleasure to be here. I am sorry we're not all in person, but this is a world of Zoom University that we are all enrolled in, whether you like it or not. Happy Constitution to everyone. It's one of my favorite holidays. You may not know this, but there's actually a federal law that says schools that accept federal money, such as this one, are required by statute to put on a program to discuss the federal Constitution on Federal Constitution Day. Now, I actually think this statute's unconstitutional. I think it's compelled speech. I think there's constitutional bars and spending, but I won't get into that now. I am here at my own volition, not because I have to be, and I'm sure Professor Kelso is wincing right now, but I'm happy to be here. Let me take the other half of the COVID debate. Professor Kelso discussed the rights half. We think about the First Amendment, free exercise of religion. We think of the 14th Amendment, the Equal Protection Clause. But that's only really the second half of the common law class that we all study. The first half that we study is what's called structure. And in many regards, the structure of the Constitution affects this debate as well. And when I say structure, I'm speaking of federalism, both horizontal and vertical. Right? We talk about the separation between the three branches of government, the executive, the legislature, and the judicial. And we also talk about the separation of powers between the states and the federal government. And both of those separations impact the way that the government can respond to a crisis like COVID. So let's start with a very basic level. We've been living in this world for the last 6 months or so. It feels like it never started, never finished. It's like Groundhog Day, just every day is the same day, just a different Zoom screen. Since the beginning of this crisis, the states, the governors, have taken the lead in the response. And different states have responded in different fashions. Some states have had very stringent lockdown measures. Other states have had more lax lockdown measures. Some states have had none at all. We've not had a single federal lockdown approach. Now, some may try to lay that blame at the feet of the president, and maybe there's some blame to be laid, but under our system, we don't have a single federal police power. Each governor is empowered with authority by the state to respond in various types of crises through quarantine measures, through restrictions on various businesses, to restrictions on public gatherings, and so on. So in our system, the responsibility falls primarily to the states to decide how to protect the health and safety of their people. But we had a strange wrinkle because COVID is not stationary, right? COVID doesn't stay in one place. It's this virus that spreads, and it spreads asymptomatically, so you may not even know you have it, even if you're spreading it. And we saw in the immediate outbreak back in February and March, when we didn't really know what was going on, one of the first efforts was to try to stop COVID from entering. So bans were imposed on people traveling from certain countries. And later, we actually had restrictions on people traveling from certain states. You actually had governors putting state troopers at the borderline. And they were pulling over people from out of state. I think at one point, the governor of Rhode Island ordered her state troopers to screen anyone coming in from New York. Now, if I had asked Professor Kelso or Professor Rhodes last year, can governors put up checkpoints to stop people from driving to a state? Like, who the hell would do that? Why would that even be a thing? That's just, it wasn't even in my realm of thought that might be something we're confronting. But in the span of days, governors erected these measures. If I want to go fly home to see my parents in New York right now, I'll be subject to a 14-day quarantine. I'll have a contact tracer come visit me daily, and they do, by the way. They actually come by and say hi to you, make sure you're not misbehaving. And it's fallen to the states to try to manage their own affairs in what is truly a global pandemic. And the upshot is we don't have a 50-state solution. We don't have a single set of policies. So in some states, restaurants are open at a certain capacity. In other states, restaurants are closed. And in other states, restaurants can open without any restrictions. And I think we've seen the states impose restrictions in three primary areas. Professor Kelso mentioned religious worship, and I think he accurately stated the cases. Chief Justice Roberts favored this sort of comparator approach that says if you're treating similar secular businesses in a similar fashion, then you're fine. Justice Kavanaugh would treat the free exercise of religion as a most favored right. And the presumption is you have to give the religious worship whatever the best treatment is. I'll just pour a little bit of salt on the Chief's opinion. That case arose what's known as an injunction pending appeal, right? It's this sort of emergency injunctive relief. And I think the Chief was very candid in saying that at this juncture, we don't know very much. We don't like granting injunctions at the early outset. I think if a case arose on summary judgment that is not an injunction, I'm not sure if the Chief comes out. There may be some play in the joints. Keep in mind, every month we're dealing with COVID, we learn more and more. And some measures that maybe made sense in March don't make much sense anymore. There was actually a case a couple days ago from Pennsylvania where a judge was considering the governor's designation of what's essential. And he said there was absolutely no thinking behind it. It was completely arbitrary. There's evidence in the record, there's depositions, there's testimony. It's completely random what is and is not essential. So I think the Chief may go, but maybe yes, maybe no. We'll see what the court does maybe later this year. The second area where we actually saw litigation involves guns. In most states, to purchase a gun, you need to go to a licensed firearm dealer. In some states, you can buy without, but generally you have to go to a licensed firearm dealer. I did a survey for an article, and I think about 30-something states, 35, 36 states, gun stores were designated as, quote, essential or life-sustaining, or different labels, but it all means the same thing. Indeed, the federal government issued guidance which also said that firearm stores were considered critical infrastructure, and most states followed that. But some states didn't. Those states were very reluctant to defend those policies because if you're not able to obtain a firearm, there's basically a complete prohibition on owning one. You can't get it. Now, if you have them before, good for you. But perhaps if you want to buy one, you've been able to. Several states tried to exclude gun stores from the list of essential businesses, which was a complete prohibition on bearing arms. Those states quickly abandoned their policies. As soon as they were sued, they didn't even attempt to defend their policies in court, and they settled with the parties. Except for 2 states I'll get to in a minute, or actually 3 states. One state, in Massachusetts, they initially allowed firearm sales because the governor was a Republican, and then the Attorney General, a Democrat, flipped out and they reversed their policy. They were sued, and they made it illegal to sell guns in Massachusetts. They were non-essential. A federal district court judge ruled that was a violation of Heller, the Second Amendment case. The government did not even file a notice of appeal. They just let it go. And they opened up the gun stores, subject to social distancing. You see, the reason why the gun stores were shut down was not because the guns themselves were dangerous, but the process of buying the gun may spread corona. So it was a different wrinkle. It's not that the guns were dangerous. Guns don't kill people. People cough kill people, right? If you go to a gun store and start coughing, you may actually spread COVID. Randy's wincing. And you could, we're all friends. So it was a different argument. There was one law in Connecticut, though, that was different. In Connecticut, to obtain a firearm license, you need to be fingerprinted for a background check. And the state ordered no more fingerprints. We are not doing background checks. We do not want people coming into the police station to get fingerprinted, which was a complete and categorical ban on buying firearms. You could not buy a gun without getting the fingerprints from the state police. In that case, also, a district court ruled that the fingerprint ban, so to speak, was unconstitutional. So we actually had, by my count, 2. There were only 2. You had 2 district courts who ruled that making it illegal, impossible to buy a gun, was a violation of the Second Amendment. Okay, now there were other cases that upheld them. New York had a very strange policy. In New York, gun stores were closed, but Walmart could stay open. And Walmart sells guns. So you had this weird scenario where these big box stores that sell guns could stay open. But, a small firearm store that has maybe 2 people inside has to close. I don't know, that seems pretty irrational to me. I mean, I'm sure you could say maybe there's more ventilation, there are taller ceilings, fewer places to inspect. I don't know, I'm sure we can make something up in the rational basis. That seems pretty arbitrary. But still, if you were in New York and you want to buy a gun, you could buy one, right? You didn't have to travel. You didn't have to go, too far. There were stores throughout the states. So the court upheld that regime. And I think that was probably right, although I still think the New York policy is just vindictiveness against gun stores. That's the reason why. If you can buy a gun at Walmart, you should be able to buy a gun at a gun store, but whatever. There was another set of cases from California. Not the state of California, but certain counties in the Bay Area in Northern California. I think it was Alameda County, Marin County, and a few others near San Francisco. And those counties had flat categorical bans on buying guns. All gun stores were closed, no Walmart, nothing. You couldn't buy, actually I don't think Walmart sells guns in California, but you couldn't buy a gun in those counties. Again, the impact was limited because if you lived in one county, in theory, you could drive to another county that didn't have this ban. So maybe you have, an hour. I mean, this traffic's not as bad now in San Francisco, but, you'd have to drive a little bit to get out of the Bay Area, but you could find a gun store and buy it. There, the court upheld it, and they didn't really have any balancing. They said that during this crisis, the state has authority to deem what's essential, and there's an obligation to deem gun stores essential. I don't think that squares with Heller. Although because they can go to other stores in the state, it probably wasn't, you didn't need injunctive relief, but I think it's hard to square with Heller. The third major area where I think the states have had litigation concerns abortion, of course, but not the usual type of abortion cases. You may recall immediately after the COVID epidemic blew up, there was a nationwide and massive shortage of PPE, personal protective equipment. Who even knew what that was? I mean, maybe you knew, but that wasn't an acronym most people knew before March. I think by my count, I did a survey, 36 or 37 states prohibited elective surgeries. It said all elective surgeries must be postponed. So that could be dental work, that could be a nose job, that could be, some kind of routine procedure that could be postponed. The states had very different definitions of what elective meant. But I think 36 states prohibited elective surgeries. And the thinking was, we don't want people wasting gloves and masks and N95 and gowns and different protective equipment for, getting a nose job, right? You don't need that nose job that badly. You can just wait. Okay. A couple states, by my count 4, it was Texas, Ohio, Oklahoma, and Alabama, if memory serves, took the position that abortion was not an essential service. So this raises some somewhat novel questions about abortion, right? Usually when the state puts a limitation on abortion, they're asserting an interest in either the health of the mother or the protecting fetal life, what they call the potentiality of fetal life, right? Usually it's the woman's health or protecting fetal life, right? Those are the two major interests in most abortion laws, whether it's a ban on a particular procedure or maybe saying you can't do it after X weeks, right? Or you have to have certain surgical standards or different things, but they're all health of the woman or potentiality of life. Those are the two interests. But here the state had a very different interest. It wasn't protecting fetal life or protecting the woman. It was protecting the community at large, right? We need to preserve the equipment. And if these procedures are using this equipment, we need to postpone these procedures. Okay, so the obvious response is, can you postpone abortions? In Texas, maybe Randy knows, I'm going to blank on the week limit, but after a certain point, it becomes very difficult to obtain one. I can't remember the number of weeks, but there's a limit. So Texas says, well, we're going to postpone abortions for initially it was a month. If you would be pushed past the limit, in other words, I'll just say 15 weeks, just I'll make up a number. If you're pushed past 15 weeks, you can get one, but you're going to have to wait until you get to that limit, because maybe when you get to that limit, we'll have more PPE. They also prohibited medical abortions, which is basically a pill you take, which could require PPE, but it's usually not surgical. It's usually you take the pill and you go home. This was litigated up and down and up and down and up and down between the district court and the Fifth Circuit. Judge Yackel in Austin gets all the abortion cases. He loves those. And the Fifth Circuit loves reversing him. It's just, it's just this symbiotic relationship. Or is it parasitic? I don't know. But anyway, it just bounces up and down, up and down. In the end, the Fifth Circuit, I'm summarizing like 4 opinions. The Fifth Circuit held that there's no right to get an abortion when you want it, that it can be delayed. And the state has compelling interest in delaying these procedures to preserve PPE. Ultimately, this never went to the Supreme Court. Why? The governor's order expired, right? By the time we got to April and May, we had enough masks, we had enough gloves, and there wasn't a need to maintain this. But for some period, we did have this limitation in abortion in Texas, and women had to go out of state. They went to Oklahoma, they went to Colorado, they went to New Mexico. There are all stories about this in the news. No Supreme Court review, but there is a Fifth Circuit precedent on abortion. And stay tuned after the Supreme Court's term. We'll probably have some shifting in that area as well. So I don't even know what that means going forward. But let me return to the point where I started. All of these steps were being taken by the states and not the federal government. And that's a reflection that the Constitution delegates to the states the authority to protect the health and safety of their people. And these cases also illustrate the interaction between the states and the courts. In some cases, the courts are very deferential to the state. I think Randy mentioned in the religion cases, some of the business cases, in the gun cases I mentioned from California, they're just very deferential. And the thinking is, in the middle of this epidemic, this crisis, this pandemic, we don't know where it's going to end. Let the people who are accountable make the tough decisions. In other cases, courts become more skeptical. And I think that skepticism increases month by month, right? As we move further from March, when we all went on lockdown, some of the things that seemed really, really important and really, really logical start seeming kind of, do we really still need that? And I think what we'll start seeing is governors who are afraid of losing court repeal their orders, which is fine. I guess I would much rather a governor repeal his order on his own accord than have a court, kill it. It's always better when government acts voluntarily than having a court intervene. So I don't know if these cases ever even get back to the Supreme Court. I think governors will just start mooting their cases to avoid an adverse ruling from the court. Of course, I haven't mentioned the huge gorilla in the room, which is elections. There's an election coming up in about a month and a half, I think. And voting will be impacted by these measures. So in those cases, the court very well may need to intervene. In that area, at least, I think Randy will agree, the court has not been eager to intervene in the electional cases. They're very willing to just let the normal rules play out. So that might be a shift from how the religion case has been viewed. All right, we're at 20 minutes. I'll stop here. I thank you. I thank Sergio. I thank the Federal Society. I thank the library staff for hosting us virtually. And also my good friend Randy for taking time out of his day to visit us from the corona of the Earth. Where are you now? You're in orbit? I can't quite tell where you are. Yeah, he's
Yeah, I'm up in space.
He's up in space. Well, I'm back down here, ready to roll. All right, let's take some questions from the students. I'd be happy to hear from you. Thank you all so much. All right, so maybe we should do it, the blue hand approach. If you have a question, you're welcome to. Oh God, I just want to name the situation. Do I even want to know? I'm a Jersey Shore fan, by the way, so this is just you're just asking for it.
Hey, how you doing, sir?
Oh, it's you. Okay, go ahead.
Yeah, I officially changed my name to the situation, given my recent, physical training workout. My abs were looking about like Mike's, about 10 years ago.
Oh God, go on.
Hey, so my question, sir, is for either panelist, but my initial thought was about that any sort of regulation would be general police power, but then I was thinking about if Congress wanted to get creative. I mean, Katzenbach and McClung and Heart of Atlanta, is a lot of the effects were felt by restaurants and businesses. And so, there's definitely an economic activity to, the public health. And public health at a federal level, certainly has a substantial effect on our economy. I think we've seen that. So if we were to pass a federal law, because as you said, Professor Blackman, that the virus is not stationary, it definitely is interstate, would the Commerce Clause provide an avenue to do that? Maybe one restaurant, without face mask isn't that bad, but in the aggregate, every restaurant without face mask, might, lead to more, significant effects, and if, would this court uphold something like that, or maybe find an avenue through the taxing power, or what are your thoughts about Commerce Clause potentially as an avenue?
I went over this exact question in class. Okay, so some of my students I think are in this room, so this is repeating for you. The Supreme Court has held that Congress can regulate local economic activity that has a substantial effect on interstate commerce. So local economic activity. Would a mandate to wear a mask be a regulation of activity, or is it not activity? And this is the lovely parting gift of the Obamacare case, where Congress cannot make you buy a commercial product under its commerce necessary and proper powers. I think Congress likewise couldn't make you wear a mask Now, if you are a restaurant, you can make your customers wear a mask. Could Congress give the state money to enact a mask mandate? Yeah. I think under South Dakota v. Dole, that would be a permissible spending program. But a straight up law requiring people who are just existing to wear a mask, I don't think that's activity. I think they have a problem under Rach and the Obamacare case.
I'll jump in and say, to me, it's a little bit trickier than that, because if you're regulating sort of wearing a mask in the context of an economic activity, like going to a restaurant to buy food or something of that kind, I actually think Congress probably could regulate that. The problem is if you have a just broad, you have to wear a mask every time you go out, no matter what you're doing, even if you're going out for a walk. Well, then I'm not sure there's an economic nexus there. Remember, the Commerce Clause, you do have to have an economic nexus to what you're regulating. So to the extent you're regulating sort of masks in the context of conducting a business, I, in a sense, Roberts would join the four liberals on that and say you could do that. But I actually am I'm not certain once you get outside of sort of masks in the context of economic activity, whether just a generic mask wearing, unconnected to any particular economic activity, you could regulate, although you could try to regulate it under the idea you've got a concern about interstate spread, and so there's a national problem, and try to do some Shreveport rate kind of thing. You can regulate within a state activity that has a close relation to affects interstate, and maybe. But I think it's really interesting because Biden came out today and said that his attorneys have told them that you could do a federal mask requirement because that's part of the political debate now. But I'm not sure they're right about that. I think a generic overall, you have to wear a mask in any activity, even just walking your dog. I'm not sure where Congress gets the power to do that. I think Congress would be on a solider ground if regulating in the context of economic activity. Then the Katzenbach and Heart of Atlanta and economic nexus comes in. But it's an interesting question. I mean, we may see that issue next year or not, depending on where we are with COVID. And do we have Biden as president?
Do I have to write another book, Randy?
What?
Do I have to write another book about this?
The
unprecedented mask mandate?
Fortunately, I hope we get a vaccine by some point next year so that this issue disappears in a year or so, as opposed to healthcare, which is continuing to go on as an issue.
My entire life.
Books on healthcare have continuing relevance. Hopefully the COVID thing won't.
Very good. All right. Thank you for the question situation. Other questions?
I mean, the absence, I'll just jump in with a couple of comments on what Josh said, which was very useful because I had not thought through the number of other, I said under the basic due process clause, it's just minimum rationality review. And then I gave the one example under the free exercise clause, it could be heightened scrutiny under that clause. But Josh pointed out that there are other sort of individual rights you have in the Constitution, like the Second Amendment right to bear arms, or the right to travel, or the fundamental right for an abortion-free viability, that also raise questions about if you're burdening them in a way that triggers strict scrutiny. Under those doctrines, then you have the same issue as in the free exercise area. Do you have a significant burden triggers strict scrutiny? And certainly the gun cases, if you're absolutely banning the ability to buy a gun, I agree, that triggers strict scrutiny under Heller. And it's not surprising you say you just can't absolutely ban the right to bear a gun. Right to travel thing, that to me is tricky. Because like telling you can't go visit family in New York without a 14-day quarantine, the question would be, is that a substantial burden on your right to travel that would trigger strict scrutiny under Shapiro and Maricopa County and others? Or would it be a less than substantial burden just triggering reasonableness review? And that's tricky. I'm not sure how a court would rule on whether the number of people who want to travel and it's a 14-day quarantine to do that as substantial burden triggering strict scrutiny or not.
Yeah.
But it's the same kind of analysis. And I appreciate it. I hadn't thought of those couple of examples. And then, of course, there was the abortion case where a few states did try to say, we're going to stop abortion for a particular length of time. And fortunately, they sort of became moot. And so we never got a result on that. But it was the same issue. Was that an undue burden on abortion that is unconstitutional or not an undue burden? It's the same issue in all of those areas.
Yeah, and the New York one's even trickier because during the 14-day quarantine, I really can't be in my parents' house. Now, I'm sort of venting, but, the state says, we'll put you up in government housing. Oh, Lord, help me, right? That's, I'll put one of the homeless shelters in the Upper West Side.
But the nature, impact of that, likely impact of that, is going to be viewed as substantial rather than not substantial. That'd be a really close case, I think.
It's actually really, I think about these things, but do I want to go and get arrested for a test case? That'd be a great test case, Super rid of habeas corpus to let me out of the jail because of the right to travel. Lainey, I see your hands up, please.
Yeah, so just on that, if you go be a test case, Randy can be your co-author, Randy, but you could have two Randys.
I'm blessed with Randys in my life.
So my question is, when you said the fingerprinting was a direct ban on guns,
Well,
is it incorrect? And the reason I'm going down that path is we had to submit to fingerprinting for our declaration to intent, for the bar exam. I had to submit to fingerprinting to get my real estate license. I had to submit to fingerprinting again to get my broker license. So is fingerprinting banning all of those activities also?
No, I'm sorry. I think I might have misspoken. The state usually requires fingerprints, but because of COVID, they said we're not letting people get fingerprinted during this period, right? Because they don't want to have people coming to police stations to touch the fingerprint plate and spread their germs. So the fingerprinting regime has been upheld. I don't like it, but it's been upheld for purchasing a firearm. But the state didn't even let you get fingerprinted during the COVID period. That's the issue there.
But I'm saying it wasn't directly about guns. Not being allowed to get fingerprinted affected a lot of activities.
Exactly right. And this is the comparator approach, right? This is something that Professor Kelso mentioned a few moments ago. The state didn't say we are banning fingerprinting because we don't like guns. They're saying we're just banning fingerprinting, right? Altogether. Similarly, the governor of Texas has ordered to not say we are banning abortion. It said we are banning all non-elective procedures. No, I'm sorry. We're banning all elective procedures. And he didn't actually say it was abortion. That's how it was interpreted by the Attorney General. So in a lot of these cases, the governors were very cagey. They weren't saying exactly what they intended. A couple politicians said, yeah, we don't like guns. We shouldn't have them. They sort of blabbed they shouldn't have. Like the governor of the Massachusetts AG tweeted, we do not need guns during this pandemic. And the governor of New Jersey said, I'm paraphrasing, he said, I think during a pandemic, we need fewer guns, not more guns, right? They were stupid. They shouldn't have said that, which I think hurt their court cases, right? Then they're very obviously targeting a specific exercise of a right. I think that makes it harder to win.
Even under the most broader, if it's facial discrimination or clearly a motivating intent to discriminate, if you go and admit what your motivating intent is,
you're going to lose.
You're in trouble.
You're going to lose.
That is the dumb thing.
Yeah. Thanks for the question, Lainey.
We have another question.
The reason they said it was direct is because they tipped their hand about what they were really doing.
Yeah, sometimes.
I just thought it's indirect.
Direct versus indirect. Maybe you're thinking of the Hammer versus Dagenhart test, right? I think from first semester. This was an absolute ban. They didn't directly ban it, but the effect of it was to absolutely prohibit acquiring a firearm.
So I received another question via message here. What are your thoughts on the government tracking COVID results by the Social Security numbers?
Ooh, Randy, you want to take that one?
Well, there are some cases involving sort of a fundamental right of disclosure privacy. The Supreme Court has, in a few cases, said, well, we'll assume there's a fundamental right of disclosure privacy. They never held there is, but they said we'll assume there's a right of fundamental privacy. And then the question is the government activity a substantial burden on that right triggering strict scrutiny, or is it a less than substantial burden because you've got sufficiently understandable privacy protections in mind in terms of the information you're collecting? And some of those cases, like Wayland v. Roe, do involve public health and safety issues. The government's trying to collect the information for public health concerns. And at least in the prior cases, the court has always said, you got legitimate interests in collecting data for public health concerns, and they've always found whatever the government regulations were were a less than substantial burden, that there were enough privacy protections for your information that it didn't trigger strict scrutiny. So they upheld it. As for what the government's doing now, I'm not certain exactly how the government's regulation is drafted, but I'm perfectly prepared to accept that it probably wasn't thought through very well. And it wasn't carefully drafted.
Nope.
It doesn't have the kind of privacy protections you may have had in some earlier cases. But the issue that in that case would be, if the court then was squarely faced with it, would they say there is a fundamental right of having your private medical information not disclosed or not? And some of the conservatives have sort of suggest they don't think there is such a right. So it would sort of be an odd case where, first, to have a constitutional case, you'd have to actually find there's a right. And I'm not sure there are 5 votes on the court to actually find there's a right. But even if there is, depending on how the regulation's drafted, and it might be one of those things that you sue and then the government changes their regulation and there's regulation 2.0, and then you sue and then there's regulation 3.0, and eventually you get it right and the government can do it, like in the Trump travel ban, where you had 2 regulations which were not well drafted and probably weren't constitutional. Then the 3rd Trump travel ban passed the Supreme Court 5-4. You might have, at the end of the day, that happened. So the reality is, my guess is the government's tracking, they're going to find a way to track, and if they have to adjust it somewhat in a court case, they would.
Yeah, there's also the issue of public universities using these contact tracing apps. I think, I'm getting in trouble here. You all need to use this app to enter the building. That thing's tracking you. It's recording where you're going. Now, I know there's limitations. I'm skeptical. Once information is collected, I just assume it's out there in the world for the Russians to have. I just assume it's gone. I don't pretend it's secret. So if you're a state institution and you're tracking your students throughout campus, everywhere they go, where they live, there's privacy implications. What happens if, I'll use an example. What happens if a person walks to an abortion clinic and that's something that's tracked and released? That can be used for blackmail. That can be used for humiliation. What if someone walks into a place known where drugs are sold? What if a person walks to a home where their mistress is living and they're having an affair? Right? There are things that you maybe don't want people to know where you are, and these apps track you everywhere you go. And the information is being shared with universities. Universities have never done this before. They have no background in doing this. It's sort of just made up in the last month or two to get people back on campus. Forget the Constitution for a minute. Even on Constitution Day, there's statutory privacy protections that states have and some federal protections have that you may actually have damages against institutions that fail to safeguard your personal information. I think a lot of these companies have built these apps almost overnight. They might get burned if there's a massive document hack, and figure where every single person in a given university has been, who they've been with. That's information that I'm very nervous about. Now, I know you have to use your app for Enter South Texas, so too bad. But this is
universities.
What's that?
We're private universities.
Yeah, statutory, Randy. There's some privacy laws. I'm not sure if in Texas, but some states have laws that prevent disclosure of data, and I think some private colleges will be snagged by this as well. I haven't been in the building since March. I have not downloaded the app for that reason. I'm getting in trouble now. They shouldn't have invited me for Constitution Day. I once did a Constitution Day event for a bunch of high school kids, and I told them never talk to the police. Never, under any circumstances. Ask for a lawyer. And the teacher like, what are you saying? Like, I'm telling the truth. Don't talk to the police. And they say, don't ask for your parents. Ask for an attorney because your parents will make you talk to the cops. And the teacher never invited me back after I got thrown out. So unfortunately, you're stuck with me. I'm sorry. All right, maybe one more question. We're almost at the hour. I don't want to keep people late.
Anybody? One more question.
That's it.
Maybe done.
Thank you, Randy. Thank you, Sergio. Appreciate it.
Thank you so much, and thanks to everyone for joining us, and happy Constitution Day.
Happy Constitution Day, everyone. See you around.
Thank you guys very much.